Hey everyone, get ready because today's case takes sovereign citizen chaos to a whole new level. This isn't the usual situation where someone just rambles about rights or imaginary legal authority. Instead, this woman was fired from her job as a correctional officer after she was accused of trying to smuggle drugs into the same jail where she worked. And rather than hiring a lawyer during one of the most serious moments of her life, she decided to represent herself in court on the very day she had to face the consequences. The full trial lasted more than 5 hours, so I'm not going to walk you through every minute of it. Instead, I've picked out the most chaotic moment from the middle of the trial and the intense final confrontation that you really need to see.
Record, just in case it wasn't clear during the bench conference, there was an objection made. Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really. I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay, so yes,
Lieutenant Grady.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger, I was in danger, and there was a instance that happened in the car. But I'll
be honest with you.
Honestly, I still can't figure out what she's actually trying to say. Her statements sound like half-formed thoughts thrown together randomly, as if she's pulling cards from a shuffled deck that don't connect in any meaningful way. One moment she talks about being assaulted, and the next she suddenly claims she has chlamydia. Then out of nowhere, she starts mentioning a baby shower. She says she walks like a model, and somehow a Polaroid picture of her son was used to pressure her into committing crimes she insists she never committed. At this point, I'm not even trying to analyze what she's saying anymore. I'm just sitting here wondering what is actually happening right now.
Or another employee there
that may have
did this sexual assault.
That may have been the one to do. I don't know who the person was.
Where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet.
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
Outside the jail, but I was working with Fulton County at the time.
All right, so the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have any reason to believe that he did?
Because if he's aware of the baby shower...
Oh, no, that's not my question, not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from anybody. It could have came from Captain Winfrey, it could have came from Lieutenant Grady, it could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail because they have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay, I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming, may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next?
Yes.
Okay, well, glad we're talking about it now then. All right, well, I think then you can ask this next witness some of these issues. You're gonna have to be careful with your phrasing. I think the state's objection to facts, not evidence, is one that could very well come again.
All right, let's see where this goes. The judge, showing far more patience than most people probably would, allows her to continue with these strange and disconnected questions she's trying to ask. The problem is that she doesn't even seem to know who she's talking about. She keeps throwing out accusations and references, as if there are many different people involved, like a whole cast of characters living in her mind, yet none of them are actually present anywhere in the courtroom.
Record, I do have the wrong person. This is not the person that was, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
What will be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report. And State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, sir.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge, that's Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches, because I'm not sure. I'm not too quite sure if that matches what I actually signed when I started working with Fulton County.
And here it comes, the classic, "that's not my signature" defense. Sovereign citizens love using this argument, as if it's some kind of magical legal escape. The problem is that she had already admitted to signing her oath of office earlier. Saying that in the same breath makes it nearly impossible to deny the signature afterward. Something tells me that argument isn't going to work out the way she thinks it will.
Is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
1:50. All right, we are now back on the record. The time is just before 2:05. It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments?
Now the jury is brought back into the courtroom, but the defendant is nowhere to be found. Because of that, the prosecution presents its entire closing argument without any challenge. There's no defense response, no rebuttal, and no interruption, just the state explaining its case from beginning to end. Eventually, the defendant returns to the courtroom, but by that time the jury has already been dismissed to begin deliberations. At that point, the damage has already been done, and there's no way to undo it.
I don't know what that is.
It's jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag, if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you can just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Pryor Street, which is south of us, and made a left at Mitchell and Pryor, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes. Yeah.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you or did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour, and I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system, so I'm not seeing.
First of all, it is not the court's responsibility to make sure a defendant shows up on time. The judge was very clear when she told her to return at 1:50. Instead, the defendant didn't come back into courtroom until almost 4 p.m. By that time, the judge had every reason to believe she could not be trusted to stay and complete the trial without disappearing again. Because of that, the court took the step it was legally allowed to take and issued a bench warrant immediately. As a result, she was taken into custody right there in courtroom, so the rest of the proceedings could continue without any more interruptions.
I think we've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond. I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record: is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
you can't
no.
deny that injustice.
And that I would just write on the note, no. and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, what I would do is say no, and then just reread the intent charge, and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole. All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact.
This is the moment when her sovereign citizen mindset fully shows up. Although it looks less like confidence and more like a flickering light about to go out, she suddenly begins a long and confusing rant about jurisdiction. She seems convinced that she has discovered some hidden legal loophole that will somehow protect her. In reality, the court system works under three basic types of jurisdiction. Criminal jurisdiction deals with crimes and can lead to fines, probation, or jail time. Civil jurisdiction involves disputes over money. Equity jurisdiction is when the court orders someone to do something or stop doing something. So yes, a lesson about the legal system definitely appeared during this moment. But unfortunately, it was not learned by the person who needed it most.
Anything else?
No, I need an answer, because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice, I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
and
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Ms. Young. That is an additional 20-day sentence I'm imposing.
you can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you
please
cannot
escort Ms. Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be hearing my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that.
And you know you're in contempt of justice.
At this point, the judge can barely even hear anything about the so-called fee schedule she keeps mentioning because she won't stop talking long enough for a full sentence to be understood. She constantly interrupts the court, interrupts herself, and still somehow expects that the strange paperwork she brought will magically solve all her problems. After repeatedly talking over everyone in the courtroom and refusing to stop, she ends up earning not just one but two contempt charges. They come back to back, almost like she is trying to break a record for courtroom penalties instead of actually defending herself.
Lieutenant Lattimore, that the jury has reached a verdict, and Ms. Young is now present back in court. And Ms. Young, I will remind and direct you once again that there are not to be any verbal outbursts, and I'll allow you to perfect the record at the appropriate time, but that is only going to be when I call on you. So with that, we can bring in the jury.
All jurors are present, Your Honor.
Thank you, Lieutenant Lattimore. Please be seated, everyone. Members of the jury, I've been informed that y'all have been able to reach a verdict. And if that is the case, it appears that juror number 8 is our foreperson. All right, if you could hand that verdict form to the lieutenant so that I can take a look and make sure it's been completed. All right, and you can hand that back to our foreperson. And sir, if you could now publish the verdict in open court by reading it, you can remain seated and read it into the record.
As to count one, possession of a Schedule I controlled substance with the intent to distribute, we find the defendant guilty. As to count two, possession of a Schedule I controlled substance, we find the defendant guilty. As to count three, crossing guard lines, we, the jury, find the defendant guilty. As to count four, possession of a Schedule II controlled substance with intent to distribute, we, the jury, find the defendant guilty. As to count five, possession of a Schedule II controlled substance, we, the jury, find the defendant guilty. As to count six, crossing guard lines, we, the jury, find the defendant guilty. As to count seven, possession of a Schedule IV controlled substance with intent to distribute, we, the jury, find the defendant guilty. As to count eight, possession of a Schedule IV controlled substance, we, the jury, find the defendant guilty. As to count nine, crossing guard lines, we, the jury, find the defendant guilty. As to count 10, violation of oath by a public officer, we, the jury, find the defendant guilty.
And that has been signed, filled in, and dated by you.
Right.
All right, if you could hand that verdict form back to the deputy so that the state may review it as well as the defendant.
Oh, I've seen this.
All right, starting with the state, is there any objection to the form of the verdict, and is there any reason this jury cannot be excused?
No objection, Your Honor.
All right, and over to Ms. Young. Any objection to the form of the verdict, and is there any reason this jury cannot be excused?
There's an object. You're still in contempt of justice.
Meanwhile, another person in the courtroom might be getting close to a contempt warning, but at least that person isn't about to walk out of the courtroom as a newly convicted felon with a strange attachment to the smell of computer duster. At the same time, the defendant is about to learn exactly how much time she may be spending behind bars for the charges a jury has just confirmed. And judging by the seriousness of those charges, it's clear this is not going to be a short stay.
I'll begin with the state to present any evidence in aggravation. And let's also start with your recommendation as well.
Your Honor, as the court is aware, the defendant, or the court may not be aware, but the defendant does not have a prior record. However, the state's recommendation in this case is not only based on the evidence in this case, but also based upon the fact that the defendant has not accepted responsibility for her actions and in the situation that she caused at the jail, and the fact that her actions potentially put inmates and other people at risk. For that reason, Your Honor, the state recommends the following sentence. With regards to counts 1 and 2, we believe count 2 would merge with count 1. State's recommendations on counts 1 and 2 are 15 years to serve 10. State's recommendation on count 3 is 5 years to serve, concurrent with counts 1 and 2. Regarding counts 4 and 5, again, the possession in count 5 would merge with count 4. State's recommendation is 15 to serve 10. The recommendation for count 6 is 5 years to serve, to run concurrent with counts 4 and 5. Counts 7 and 8, Your Honor, the state would recommend 15 to serve 10, with count 8 merging into count 7. And on count 9, 5 years to serve, to run concurrent. And then for the violation of oath, state recommends.
So here's what the state asked the court to consider. There were 3 charges that each carried a possible 15-year sentence with 10 years to serve. On top of that, there were 2 additional charges carrying 5 years each. All of those sentences were requested to run concurrently. In simple terms, that would mean 10 years in prison followed by 5 years of probation. Even by itself, that is already a very serious punishment. But what she ultimately receives turns out to be even harsher than what the state requested. And when the final sentence is announced, it hits her like a freight train.
Aggravation, Ms. Boykin. At a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang affiliation, that there were, and I know that there was a warrant taken out initially in this case about gang affiliation, and that he referenced other evidence showing that she was distributing directly to inmates. And so is that something the state is prepared to introduce in aggravation here today?
Your Honor, the state does have information related to that. We do not have the witness here to testify regarding those matters. Should the court hold a scheduling hearing or a hearing at a later date, we can have that witness available given this time of day.
All right, well, not hearing a request to continue sentencing and the evidence not...
Would request for the court to continue sentencing to hear from that witness.
And the state's recommendation, though, would remain the same after presenting this aggravating evidence.
It would, Your Honor.
All right. And just by, wouldn't consider it unless we did hear that evidence, but by way of proffer to complete the record, what would be your proffer, what that witness would testify to?
Your Honor, the witness, Raylene Bruce, would testify that she too worked at the Fulton County Sheriff's Department. She assisted Investigator Green with obtaining the defendant's cell phone. A subsequent dump of that cell phone did show that the defendant was communicating not only with inmates, but with other individuals to sell items, to sell drugs within the jail. There are also some Instagram postings for the defendant. And there's also photos of her gang tattoos that were taken
Eventually, it becomes clear that she was not only sneaking drugs into the jail for personal use. Investigators also connected her to a gang and discovered that she had been actively supplying drugs to inmates inside the facility. With every new detail that comes out, the situation becomes even more shocking than the last revelation. And the most unbelievable part is that the case still isn't finished yet. The story continues to escalate with one surprising discovery after another.